The Supreme Court has ruled that the Tamil Nadu Governor Ravi's delay on 10 bills was illegal, a jolt to his standoff with the DMK government. Governors must now act swiftly on represented laws, clipping their discretion.
In a landmark verdict that could set the tone for governors taking on state governments to fall in line, the Supreme Court today ruled illegal and arbitrary Tamil Nadu Governor Ravi withholding assent to 10 bills passed twice by the Assembly and referring them to the President. The top court granted assent to all 10 bills and laid down a clear 3-month timeline within which governors ought to clear bills. In its judgment, the apex court said action of the governor to reserve the 10 bills for the President is illegal and arbitrary, and thus the action is set aside. The 10 bills shall be deemed to be clear from the date it was represented to the governor. It also ruled governors have no discretionary powers, and they ought to abide by the aid and advice of the Council of Ministers.
சற்று முன்பு வரலாற்று சிறப்புமிக்க தீர்ப்பை நமது தமிழ்நாடு அரசு பெற்றுள்ளது. தமிழ்நாடு அரசு மாண்புமை உச்சநீதிமன்றத்தில் வழக்கு தொடுத்ததில் தமிழ்நாடு அரசின் வாதத்தில் இருந்த நியாயத்தை ஏற்று மாண்புமிகு ஆளுநர் அவர்கள் நிறுத்தி வைத்திருந்தது சட்டவிரோதமானது என்றும் அந்த சட்ட முன்வடிவுகளுக்கும் ஆளுநர் அவர்கள் ஒப்புதல் அளிக்கப்பட்டதாக கருதப்பட வேண்டும் என்றும் தெரிவித்து வரலாற்று சிறப்புமிக்க தீர்ப்பினை இன்றைக்கு மாண்புமை உச்சநீதிமன்றம் வழங்கியுள்ளது.
While delivering this landmark judgment today, the Supreme Court has sent out a strong message to the governors across the country. The top court said that the governors must be conscious to not create roadblocks for the state legislature and should act as catalysts rather than inhibitors in the functioning of a parliamentary democracy.
The 10 bills Ravi sat on aimed to clip the governor's powers as chancellor of state universities. With the bills cleared, Ravi ceases to be the chancellor.
Under the amendment which have been passed by the Assembly, the governor, because he was acting in defiance to the not only to the Constitution, in defiance to the Act, various Act which governs the university, therefore the state government felt that he should be clipped off from all his powers, he should be ousted out. And that is why the 10 bills have been introduced and passed by the Tamil Nadu Legislative Assembly. And similar types of bills have been even introduced in other states also.
It's a huge embarrassment for governors in opposition-ruled states who fail to preserve the sanctity of the constitutional immunity they enjoy. For the union government and the President, it's a major embarrassment for failing to rein in on these constitutional functionaries. With Nupur Dogra in Delhi, in Chennai with Suresh, Sam Daniel, for NDTV.
Well, joining us now, Professor Faizan Mustafa, the constitutional expert, Shadhan Farasat, the senior advocate in the Supreme Court. I'm also joined by Dr. Syed Hafiz of the DMK and Satya Mule, another senior advocate in the Supreme Court. Let me go across to Professor Faizan Mustafa first. Thanks, sir, very much for being with us. On the issue of constitutional duty versus discretionary power, under Article 200 of the Constitution, I believe, governors are required to give their assent or withhold assent or reserve a bill for the consideration of the President. But now, in today's ruling, is there an implication that the Tamil Nadu governor's decision to withhold assent, the fact that the Supreme Court has said that is illegal and arbitrary, does that mean that governors must now act swiftly and that they cannot indefinitely delay bills?
Yeah, that's the implication of the judgment. I think this judgment has far-reaching implications. In fact, on the powers and the role of the governor, probably it is the boldest of all. Because for the first time, just 1 minute, light band kar.
Sir, you're on air. Please continue talking.
Yeah. I think for the first time, the Supreme Court has laid down timelines for the governor. We need to remember that we are a parliamentary democracy, we are a representative democracy, in a representative democracy, the power should basically lie with the elected representatives of the people. Many governors in the recent past have completely made state governments non-functional, and they were simply sleeping over the bills. So I think that this is a huge judgment, not only in terms of strengthening democracy, but also strengthening the federalism. Because if opposition rule governments can't even pass laws and get them enacted as acts with the assent of the president, then they can't deliver the promises they have made to the people.
So, Professor Mustafa, the bottom line over here is that does this verdict effectively curb the discretionary authority of the governor?
It does. It does, because it very clearly lays down very clear timelines when they have to, within what time they have to assent, within what time they have to ask them for reconsideration or reserve it for the president. And since it is a law laid down by the Supreme Court of India under Article 141, it would apply across board in all states on all governors.
So the bottom line, once again, could this verdict today set a precedent for judicial intervention in cases of prolonged inaction or alleged prolonged inaction by governors across the country?
Generally the law has been that the judicial review in matters of governors' actions and the presidential actions would be limited. But in this case, the court very clearly said that since the governor, recommended the reserve these bill for the president after they were resubmitted to him, State Assembly having reenacted them, after the Punjab judgment of the Supreme Court, where Supreme Court has come down heavily on this practice of delay. And therefore, they say that the governor's action was not bona fide. And whenever any action, either by the president or by the governor, is malified, the courts do intervene. And they have intervened in this case, holding that the Governor Ravi's decision was arbitrary.
Does this ruling strengthen India's federal structure? Why? Because it ensures governors cannot override elected state governments. That's essentially what you're
I
talking
believe
about,
so,
right?
because governors largely act as agents of the center. They don't act as constitutional authorities. And in my opinion, this is so because governors hold office during the pleasure of the president. A low-level civil servant enjoys greater security of tenure, but a governor can be removed without any reason.
Okay.
So unless we give security of tenures to governors, governors would continue to behave like this. But Supreme Court has very rightly applied some brakes on their powers.
All right, sir. Thanks very much for explaining that all to us. Shadhan Farasat, Dr. Syed Hafiz and Satya Mule with us. Shadhan, let me come to you first. Let's look at the context. The context isn't just Tamil Nadu. There have been repeated struggles between state governments and the governor. So we've got Tamil Nadu. There was Kerala Pinarayi Vijayan versus Arif Muhammad Khan. Karnataka Siddaramaiah versus Thawar Chand Gehlot. Bengal repeatedly when C.V. Ananda Bose was the governor versus Mamta Banerjee. I'm not getting into each example. But the central premise of several governments in these states is that the governor was brought in on the behest of the center to act as a representative, in a sense, of the center, and therefore no business got done. With today's verdict, is that argument weaker?
Yes, so you're right. The examples you gave, each of those examples, the central government was, the ruling party at the center, I should rather say, was using the office of the governor to ensure that although they had lost political power in a state to a political rival, they nevertheless continued to exercise some power through the route of the governor. Now, as far as constitutional law in India is concerned, right from Shamsher Singh onward, which is a 1970s judgment, it's quite clear that governor is really just a ceremonial post with very limited discretion, where it is expressly provided in the constitution itself. It cannot be implied. So that is the legal position. Now, this case, specific case, arises in the context of giving assent to bills which are passed by the state legislature. There, under Article 200, really speaking, the governor has two options. If he feels that there is a conflict with a central law, etc., because it's a concurrent list matter or otherwise, he can refer it to the president for his view. or if he has a proposed amendment or some proposal, he can send with a message back to the assembly itself or the legislature if it's with two houses. Now, what it cannot do is sit on that bill or give a pocket veto, which is what has been happening. So you don't refer it up, you don't send it back, or if in this case you send it back and it comes back again with the same, the legislature reapproves the same version, then you have to give it approval. You can't do a pocket veto and therefore sit as a super legislature. The governor is not a legislature above the legislature, which is a super legislature. So I think what is the remarkable thing in today's judgment of the Supreme Court is that they have said, thank you very much. We have seen your conduct. Now we are going to read in a few things. Basically, from the day it has come back to you is deemed approval.
Okay.
I think this is a very good approach, because when you have a recalcitrant governor like this one, I think the court will also need to be more proactive. And this is not the only instance. I can think of very many other instances in the context of federal disputes where such an approach will possibly really enhance and strengthen our federalism.
Satya Mule, would you like to respond in any way to what Shraddhan says? Because I think the key part of what the Supreme Court, one of the key parts, other than the judgment itself, is the court finding that Governor Ravi did not act in quote-unquote good faith, and that obviously raises the fundamental question about accountability. How will this verdict influence the role of the judiciary in policing, the governor's adherence to constitutional norms, particularly in states where there's been a history of friction?
Well, there is another angle to it. My learned friends have already spoken a lot about the procedure laid down by the Supreme Court in this particular context. What happens is there are various other incidents and instances that come across in our parliamentary democracy, or what we can say various kind of electoral politics. What happens is many a times there will be certain instances in the past. There have been instances that the states enact their own law where sometimes it is felt that it is against certain subjects of national interest. And in those contexts, the governor should have some amount of say wherein, it cannot be deemed consent. Giving a deemed consent for that matter then leads to only one path if somebody wants to challenge that particular enactment. Let us say if it can be an individual, even for that matter, central government wants to challenge that kind of enactment, then the only path or only option that remains is go to the Supreme Court. This will lead to a lot of litigation at Supreme Court, which will be challenging various enactments. In fact, what will happen now also is that one particular door is open for various states. There will be certain states who are completely alienated with the concept of federalism. Say, let us say, for example, Kerala for that matter, in many subjects, West Bengal for that matter, in many subjects, tries to enact various laws which are not in sync with national interest, or what we can say as national, what we can say centralist. But what happens is, in this particular situation, only the Supreme Court will be the checker. Okay. There will be the only what we can say gatekeeper. That's all.
Okay. I know Shraddhan wants to respond. Shraddhan, 1 second. Dr. Syed Hafiz has been waiting very patiently. And obviously, this is something that directly impacts Tamil Nadu. Dr. Syed Hafiz, the Tamil Nadu government has repeatedly accused this governor of obstructing legislative agenda, involving 10 bills. Does this verdict affirm your state's right to govern? And do you believe that undue interference argument that you raised is now gone? Or do you believe that there is still enough ambiguity for the governor to exploit, for example, constitutional loopholes to prevent legislation from going through?
See, actually, the Supreme Court decision in this particular case about defining the gray areas which were used by the governors for their interest or for the interest of their masters. That definition has given a lot of clarity in favor of democracy, in favor of cooperative federalism, which the Constitution talks about every now and then. Now, this gray area which is used by the governors, which they felt was there in the favor, as soon as possible had no definition. So a bill has been pending with the governor's office for the last 5 years. In such a scenario, how do you expect the government to administer and govern the people who voted for them. Very categorically, the Supreme Court has put the onus and the responsibility of governing the people on the elected government. That is the parliamentary democracy we are talking about. Here in the Indian constitution, in the concept of Indian democracy, ultimately the political party which is at the power is answerable to the people. Governor has no credibility or accountability towards the people. If my learned friend who was saying issues were against the national interest, what bigger job does the Supreme Court has rather than listening to the issues concerning the national interest? How can governor be a judge sitting in the governor's office and try to obstruct everything that the opposition ruled states are bringing? Now here is a classic case of 10 bills. Right from 2020, this is not the matter of the government of DMK, but we have fought for the bills which were passed by the previous ADMK regime. 5 years, a big time. You fight election for every 5 years. Here is a governor who has stopped, or a previous governor stopped the bill for 5 years. So it takes out the complete idea of democracy which the constitution and Indian democracy talks about. The power is with the people. The people have voted X, Y, Z party. Today it's me, tomorrow it could be anybody. And that party has the ultimate power to take the call on what is good for the people. If it is wrong, we are going to the people and people are going to punish us or reward us for our deeds. But who is the governor? Governor is here today. He was in Nagaland some time back. He is in Tamil Nadu today. Tomorrow he'll go elsewhere. So that is not what the governor is expected to be. The governor has been said in previous judgments by the Supreme Court. He's a titular head. Now, two important factors come out of this judgment. As soon as possible does not mean 5 years or infinity. It means 3 months for the first time and 1 month for the next time. So within 4 months, you have to give an answer. Now, the governor has become more credible so that he cannot pass the buck. He cannot brush it under the carpet. He cannot come make public statements saying if the governor has withheld the bill, it is deemed as the bill is being killed. Who gives the power to the governor to kill a bill?
Okay, I get your point, Dr. Hafiz. Shadhan wanted to come in. Shadhan, my other question, where does this leave the governor of Tamil Nadu presently? He's been given a Supreme Court order. He has to oblige by that Supreme Court order. But where does that leave him with the state government?
Yeah, I'm thankful for that question. Actually, I was going to come in on that. I think given the kind of order Supreme Court has passed, my personal view is that either the governor should be sacked by the central government or he should resign. I mean, with this kind of a scathing order against him in the second round of litigation, he has no moral or legal right to continue. And if he doesn't have the grace to actually resign himself, I think it's incumbent upon the central government to actually fire him. Because after this kind of, by the top constitutional court, he's called out with fundamental violation of elementary norms of propriety, which is expected of a constitutional post, I don't think he has any business continuing in that post. I just wanted to counter the point which was made by the co-panelists, that the governor's job is to look after national interest. I'm sorry, that's not the point. Every state has a state list. The reason why you have certain areas allocated to the states is because every state can differ. We are not a country which is run only by parliament. On certain aspects, parliament has the power. On other aspects, state legislature has the power. So obviously, state legislatures will differ. What is fit for Tamil Nadu may not even be fit for Karnataka, leave alone for Uttar Pradesh. So therefore, there's no concept of uniformity. There's no concept of one national being, one uniform being. That's the entire idea of having multiple lists for legislation in a constitution. So my learned friend has got that completely wrong. The purpose of in fact, one of the fundamental questions today, I would go so far as to say, do we even need a governor? Possibly not. I mean, apart from giving them a fancy house, and they really don't serve any purpose. I don't even think we need to revisit the position of a governor, because the only purpose it seems to serve is the purpose of abuse.
Okay, Shadhan, half a second. Satya Mule, sir, would you like to respond to the key point that he mentioned at the beginning, that this governor's lost his locus standi to continue?
Definitely. What happens is that Supreme Court in its today's order itself has clarified that in no way they would like to clarify that they are undermining the position of the governor. Definitely, governor's position is a constitutional post, and it does have an important role to play. Yes, definitely the subject of discretion has been removed from the Governments of India Act of 1935. The words discretion, at his own discretion, has been removed. But that doesn't mean it allows or it has to be interpreted that a particular state legislature can go scot-free. There has to be checks and balances in Indian democracy, or for that matter, any democracy. Yes, definitely what has happened is the clarification that the Supreme Court has provided has definitely removed the gray area, and it is a welcome judgment. It is not that it is going to lead to some kind of a chaos. This kind of a judgment is welcome. But however, all said and done, this kind of judgments are required in various such gray areas where there is overlapping of power or overlapping of administrative controls between states as well as union government, which will further lead to more clarity in our democracy. That is how the democratic government or democratic format of our government will evolve further.
All right. Well, I'd like to thank all of you very much for joining us. It's a key judgment. Perhaps it'll be greater transparency in how bills go through in various states. Thank you very much for being with us.